Now we're going to move on then to the law. Well, where to start? The obvious starting point is, of course, Part 25 of the Family Procedure Rules 2010, and I hope that won't come as any surprise given that you're attending this webinar. Part 25 applications can be made within any children proceedings. We know this because of Rule 25.2 of the Family Procedure Rules, and that specifically refers us to Rule 12.1, and that says both public and private law children proceedings fall within the scope of it. Whether the evidence could be given by another person on the matters on which the expert would actually give evidence, the impact which giving permission would be likely to have on the timetable for and duration and conduct of the proceedings, the cost, and finally any matters prescribed by the Family Procedure Rules 2010. In particular, for that latter factor, I would always direct practitioners to the overriding objective, which we find in Part 1 of the Family Procedure Rules, which requires us to approach cases in a way that is regarded as just. Very often you will find that the expert does not have the relevant expertise that you are looking for, and you really do need to sometimes scrutinise what they actually have experience in before nominating and indeed instructing them if the court agrees that an expert is necessary. The second thing that I would suggest you to do is ask around. People always remember a good expert. More importantly, people definitely always remember a bad expert. I had a case involving an independent social worker who had conducted what was then a PAMS assessment of the parents.